Welcome to the Supreme Grammar Podcast, where you can learn to write like a Supreme Court Justice. With me, Jill Barton. Today, our AI hosts explain why and how law students read cases deeply to find the anchors. This is a skill you'll need from day one of your law school journey. It will help you on every reading and writing assignment and your law school exams. Let's listen in.
Welcome back, everyone. Ready for another deep dive?
Always.
All right. Well, today we're tackling something that I think every law student kind of struggles with, to be honest.
Oh, yeah.
Legal writing.
Absolutely.
We've got chapters from this book, the Handbook for the New Legal Writer, by Jill Barton and Rachel H. Smith.
Great book.
And trust me, this is way more exciting than like actually reading a textbook.
You're absolutely right. This book really gets to the practical stuff, the stuff you guys actually need.
Yeah.
It actually starts by highlighting how much lawyers write. And it's not just a law school thing.
Oh, no.
This is an everyday part of being a lawyer.
Honestly, that's kind of intimidating to think about,
Yeah.
Like, how much writing are we talking here?
I mean, think about everything. Memos, court arguments, client letters, even just emails. It's all writing. And the book even stresses that even new lawyers are doing this, like from day one.
Oh, wow.
Yeah.
Okay, so clearly we need to be prepared.
Right.
Where do we even start with all this legal writing?
Well, the handbook breaks it down into two main types of legal documents.
Okay.
Objective and persuasive.
Okay.
It's a fundamental difference that every law student really needs to understand.
Objective versus persuasive. So that sounds like two different approaches to like the same task.
Exactly. Objective writing is all about presenting the facts and the legal analysis.
Okay.
But in a neutral, unbiased way.
Got it.
It's like you're giving advice based purely on the law, Imagine writing like an office memo analyzing a legal issue for a client.
Right.
It needs to be thorough, balanced, and, completely reliable because the client needs to trust your analysis.
They do.
Yeah.
So objective writing is about being neutral and informative.
Yes.
But what about when you need to convince someone? Like that's where persuasive writing comes in.
You got it. Persuasive writing is all about crafting arguments, convincing the reader, and ultimately getting them to take action.
Yeah.
Think about those really intense courtroom scenes, That's the kind of energy that we're talking about here.
Yeah, I can definitely see the appeal of delivering a powerful closing argument.
Right.
But for those of us who aren't quite there yet, what's a more practical example of persuasive writing?
So a great example is a motion that you'd file in court asking the judge to rule in your client's favor.
Okay.
You need to build a strong, logical, credible case to win that argument.
Right.
Yeah.
This makes total sense.
Yeah.
So as law students, we need to master both these styles to actually be successful, right? It's like having two different tools
Exactly.
in our legal toolbox.
Precisely. And this is where things get even more interesting.
Okay, here we go.
The book introduces this concept of anchors in case law, and it's kind of like finding the key to unlocking better legal arguments.
Okay, anchors.
Anchors.
Tell me more. It sounds intriguing.
Think of it this way. Just as a ship needs an anchor to stay grounded,
Okay.
your legal arguments need a solid foundation. And these anchors are those core reasons behind a court's decision in a particular case.
Got it.
They help us understand why a court ruled the way it did, which is super valuable when you're trying to build your own arguments.
So anchors are like the underlying principles that drive a court's decision.
That's it.
That makes sense.
Yeah.
But how do we actually find these anchors when we're reading through case law? Because honestly, sometimes it feels like I'm searching for a needle in a haystack.
You're not wrong. It can be tricky. But the book gives us some clues.
Okay, good.
It says these anchors can be found in constitutions, statutes, the key facts of the case, or even just, within minor rules that are mentioned in the case law.
Okay.
Think of it like being a legal detective.
Okay.
You need to examine the case to uncover that reasoning and identify those crucial anchors.
I'm starting to see how this could be a game changer.
Right.
It's like we're not just passively reading a case, we're actively trying to decode it and find those hidden gems that can support our own arguments.
Exactly. And to illustrate this, the book gives us a really interesting example, a case called Bostock Ferrari, which involves a bear and a horse.
Wait, what?
Yeah. Oh.
A bear and a horse?
Yeah.
Okay, you've got my attention.
Right.
This sounds like a Wild West story gone wrong.
It kind of does, right?
Yeah.
But it's a perfect example of how to identify these anchors.
Oh.
So the case is about this bear being led down a street when suddenly a horse just freaks out, causing a commotion.
Oh, my.
Right. And the court had to decide if the bear's owner was negligent.
Okay, I'm hooked.
Good.
So what were the anchors that the court considered in this, like, bear and horse showdown?
So the book points out 5 key anchors that influence the court's decision.
All right, lay it on me.
First, they highlighted that the bear had no history of being vicious.
Okay.
It was essentially a harmless bear just going for a walk.
So anchor number 1.
Yes.
The bear wasn't known to be a troublemaker.
Exactly.
Got it.
Yeah.
What else did the court consider?
The second anchor was that the bear was under the control of its handler and was walking calmly on a public street for a legitimate reason.
Okay.
They weren't causing any trouble or disrupting the peace.
Right. It sounds like the bear was just minding its own business.
Totally.
So what were the other anchors that the court took into account?
The third one was that the bear's owner had taken precautions to ensure the bear was securely leashed,
Right.
demonstrating responsible ownership.
Yeah.
They weren't being reckless with a potentially dangerous animal.
Right. Yeah, it seems like the owner was doing everything by the book.
Yes.
So what about the horse?
Yeah.
Did its behavior play a role in the court's decision?
Absolutely.
Yeah.
That brings us to the 4th and 5th anchors.
Okay.
So the court noted that the horse might have just been lacking courage or discipline.
Oh.
Basically, it overreacted to seeing a bear. And lastly, there was no evidence to suggest that the bear's owner knew their bear was, particularly likely to scare horses in general.
Wow. So even the horse's, personality ended up being a factor in the court's decision.
Right.
I never would have thought about that.
Yeah.
This Bostock-Ferrari case really shows how, subtle and unexpected these anchors can be.
They can be.
It really is like playing legal detective.
It is. And once you start to recognize these anchors in one case, you can begin to see patterns.
Right.
And apply them to other cases with similar issues.
Yeah.
But here's where it gets more complex. What happens when you have multiple cases with different outcomes on the same legal question,
Yeah. Yeah.
How do you navigate those inconsistencies?
That's a great question.
Yeah.
It feels like we need to level up our anchor game even further to, handle that.
You're right. That's where the idea of synthesizing anchors comes in.
Ooh.
It's about taking those puzzle pieces from different cases and putting them together to form a clearer picture of what the legal landscape really looks like.
Right.
Yeah. Yeah, it's like taking those anchors from the individual cases and using them to build a stronger, more stable foundation.
So instead of just focusing on, the very specific details of one case,
Right.
we're looking for those broader principles that can connect multiple cases.
Exactly.
Right. It sounds like a way to make sense of those seemingly conflicting rulings that, we sometimes encounter in case law.
Exactly. And to illustrate this, the authors actually use a really classic example, dog bite cases.
Oh, okay.
Yeah. So imagine you're researching a case where your client's dog bit someone, right? Naturally, you'd start looking for similar cases to see how courts have ruled in the past.
Right, of course.
But as you mentioned, sometimes these cases might have different outcomes, even though they all involve dog bites.
Yeah, that makes sense, because every dog bite case is unique.
Right.
One might involve a dog on a leash.
Right.
Another might involve a stray dog.
Yeah, exactly.
The context matters.
Precisely. And the handbook emphasizes how synthesizing anchors helps us navigate those nuanced situations.
Okay.
So let's actually look at their example.
Okay.
So they analyzed 2 dog bite cases with contrasting rulings to show how the synthesis works in practice.
Okay, I'm ready to walk through these cases.
Okay.
What were the anchors that led to those different outcomes?
Okay, so in the first case, the deciding anchor was that the dog owner hadn't leashed their dog.
Okay.
And the person who was bitten hadn't provoked the dog in any way.
Right.
It was a pretty clear-cut case of negligence on the owner's part.
So the owner's failure to restrain the dog was crucial in that case.
Yeah.
What about the second case, where the ruling favored the dog owner?
Right.
What were the anchors there?
Okay, so the second case had a different set of anchors. In this case, the owner had securely tied their puppy outside a store.
Okay.
And the person who was bitten had approached the puppy voluntarily and tried to pick it up.
Oh.
So in this scenario, the court focused on the actions of the person who was bitten.
Okay. Not just the dog owner's actions.
Interesting. So even though both cases involved dog bites, the anchors, the specific reasons behind those rulings, were different.
Right.
But how do we, go beyond analyzing individual cases like this and develop a more comprehensive understanding of the legal principles at play.
That's where the real magic of synthesis happens.
Okay.
The handbook points out that we can actually combine the anchors from these two seemingly different cases into two broader concepts that can help us analyze future cases.
Okay. I'm intrigued. What are those two broader concepts? How do they connect these dog bite cases?
Okay, so the first concept focuses on whether the dog owner made a reasonable effort to restrain their dog.
Okay.
This kind of draws on the anchors we saw in both cases. The unleashed dog in the first case.
Right.
And the securely tied puppy in the second.
Right. So we're considering the owner's responsibility to, prevent the bite from happening in the first place.
Exactly.
The second concept is whether the injured party approached the dog voluntarily or provoked it in some way.
Right.
And this takes into account the actions of the person bitten in both cases, adding another layer to our analysis.
So by synthesizing the anchors from those two cases, we've essentially created a framework for analyzing future dog bite cases.
Yes.
Even if the specific circumstances are different.
Precisely. And this is how you start to see the bigger picture in case law.
Yeah.
By synthesizing anchors, you're not just memorizing case details.
Right.
You're building a deeper understanding of the legal principles at work and how they apply in various situations.
I'm starting to see how powerful this could be. It's like having a mental map of case law.
Right.
Organized not by case names,
but
by these underlying principles, these anchors that can guide our analysis.
It's like building a toolbox filled with not just individual tools, but also sets of instructions on how to use those tools effectively in different scenarios.
I like that.
Yeah, and the authors actually don't stop there. They take this idea even further by introducing more cases to show how this synthesis process works in practice.
Okay, I'm ready for more examples.
All right. So they bring back that Bostock-Ferrari case with the bear and the horse. Remember that one?
Of course. How could I forget the horse, who apparently wasn't a fan of bears?
Right. So they build upon that case by introducing another case called Scribner v. Kelly.
Okay.
Which also involves a startled horse.
Oh.
But this time, the culprit wasn't a bear. It was an elephant.
An elephant? Wow. Things are escalating quickly.
I know, right?
I'm curious to see how this new case fits into the bigger picture.
So the core issue is similar to Bostock-Ferrari.
Okay.
Was the owner of the animal negligent in causing the horse to freak out?
Right.
But by adding this new case into the mix, we get to see how synthesizing anchors from multiple cases creates a more nuanced and comprehensive understanding of the legal principles involved.
So how do the anchors in Scribner v. Kelly compare to the ones we saw in the bear case? Are there any similarities or differences that stand out?
One key similarity is that in both cases, the court determined that the owners weren't aware of any dangerous tendencies their animals might have.
Okay.
This reinforces that important anchor of the owner's knowledge, or lack thereof, about their animal's propensity for causing harm.
Right. So in both cases, the owners couldn't be held responsible for something they couldn't have, reasonably foreseen.
Exactly.
Did the court in Scribner v. Kelly consider any other factors that were, similar to the bear case?
Yes. Just like in Bostock-Ferrari, the court in Scribner v. Kelly also highlighted the horse's reaction. They pointed out that the horse wasn't actually injured by the elephant. Its fright was simply due to seeing a large, unfamiliar creature. This, again, suggests that the horse itself might have been a bit skittish or easily startled.
It's like those cases are teaching us to consider the full context.
Yes.
Looking at both the actions of the animal and the reactions of, the person or animal involved.
Right.
It's not always a simple, black and white situation.
Exactly. And to further drive home this point about synthesis, the handbook introduces yet another case.
Oh, my goodness.
Thompson v. Lee. This time it involves a motorcyclist colliding with, you guessed it.
Don't tell me, a cow.
A cow.
Okay, a cow. Now we've got a bear, an elephant, and a cow.
Oh, no.
I'm starting to see a pattern here. Each case, while unique in its details, adds another layer to our understanding of, what constitutes negligence when animals are involved.
You're getting it. It's like we're building this mosaic of understanding using these different cases to create a more complete picture.
In Thompson v. Lee, did they say anything about the cow?
They did. So the court emphasized that cows, unlike bears or elephants, aren't typically considered dangerous or ferocious animals.
Right.
The owner had no reason to believe this particular cow would cause any trouble, and they weren't even aware that it had escaped from its enclosure.
So we've got 3 cases now, each with different circumstances, but with some overlapping anchors emerging.
Yes.
It's like we're starting to see those common threads that connect seemingly disparate cases.
Precisely. And that's exactly what the handbook wants us to do, synthesize the anchors from these 3 cases to extract those overarching principles that can guide our legal analysis.
Okay, let's put on our synthesis hats.
Yes.
What common themes emerge from these 3 animal encounters? What are the key takeaways that can help us understand this area of law?
Okay, so the handbook distills all those anchors into 2 primary considerations for analyzing negligence in cases like these.
Okay.
First, they highlight the importance of considering whether the animal itself had a known tendency to be vicious or frightening.
Oh.
And conversely, whether the injured party was known to be easily scared or prone to overreacting in certain situations.
So we're looking at both sides of the equation. The nature of the animal and the disposition of the person or animal involved, it's a two-way street.
Exactly.
What's the second consideration they emphasize?
The second key consideration focuses on the owner's level of responsibility.
Okay.
Did they take reasonable precautions to contain the animal and prevent any harm from occurring? And were they aware of any dangerous tendencies the animal might have had, or the fact that the animal had escaped?
It's all about, reasonable precautions and foreseeability. Whether the owner could have anticipated this incident happening based on, what they knew.
Exactly.
This synthesized framework is incredibly helpful. It's like having a cheat sheet for analyzing any case involving animals causing harm.
That's a great way to think about it.
Right.
And imagine how much stronger your legal writing will be when you can back it up with this kind of synthesized understanding of case law.
Right.
You're not just citing random cases.
Yeah.
You're demonstrating a deeper grasp of the legal principles at play.
Right.
And how they connect across different factual scenarios.
I'm starting to see how this approach can take my legal analysis to the next level.
Right.
It's like going from simply memorizing facts to truly understanding the logic and reasoning behind, legal decisions.
That's the heart of it. It's not just about regurgitating information. It's about critically analyzing it, synthesizing it, and using it to craft compelling arguments that persuade your reader.
Before we wrap up our deep dive, let's summarize those key takeaways for our listeners.
Let's do it. First and foremost, we learned that writing is an absolutely essential skill for any aspiring lawyer. It's not just something you do in law school to, get good grades. It's an integral part of your everyday life as a legal professional.
Yeah, and we can't forget those 2 fundamental writing styles we discussed. Objective and persuasive writing. Objective writing is all about being neutral, right? And presenting the facts and legal analysis clearly and impartially, like in an office memo or when advising a client.
Right. And then there's persuasive writing, where you get to tap into your inner advocate and build those compelling arguments to convince your reader, like you would in a motion or a brief.
Right. But the real game changer for me was learning about those anchors in case law. They're like hidden treasure, revealing the reasons behind a court's decision. And they can really make all the difference when you're building your own legal arguments.
Absolutely. We talked about how to find those anchors by carefully analyzing cases, looking beyond the surface to really understand the court's reasoning. And then we took it a step further by learning how to synthesize anchors from multiple cases to gain a broader perspective on the legal principles at play.
Yeah, that synthesis part was eye-opening for me. It's like we're not just memorizing individual cases, but creating a mental framework that helps us understand the bigger picture of how the law actually works.
Exactly. By mastering that skill, you're not just citing random cases, you're demonstrating a deeper understanding of the legal principles and showing how they connect across all these different situations.
And for all our listeners out there embarking on your legal journey, just remember to embrace those 2 key writing styles. Harness the power of anchors in your legal analysis, and never stop exploring the fascinating world of case law. Who knows what other hidden gems you might uncover.
So anchors are like hidden treasures in case law. They're about looking beyond the surface of a case so you understand more than the court's reasoning. You also gain a deeper understanding of the legal principles and how they connect against different factual scenarios. Thanks for listening, and remember, you can be a great legal writer.